Hey guys, the anti-SLAPP ruling is here. Let's hit the highlights. It's quite long. So remember, this whole thing about anti-SLAPP is a two-pronged test. The first prong is the conduct that the defendants want to protect has to be covered under the statute. Some kind of speech or that sort of thing that falls within the definition of the statute. To me, it wasn't really ever in question they'd be able to do this because it's quite broad, and they did succeed here. If so, it moves to the plaintiff to show he has some evidence to support the necessary elements. So on prong one, the court says the only thing the defendant needs to establish to invoke the protection of the SLAPP statute is that the challenged lawsuit arose from an act on the part of the defendants in furtherance of her right of petition or free speech. They did that. Now it switches to the plaintiff to demonstrate that the complaint is both legally sufficient and supported by sufficient prima facie showing of facts to sustain a favorable judgment if the evidence submitted by the plaintiff is credited. So in other words, if it's speech stuff, Manson's going to have to show he's got some evidence for each of the elements of the claims he's got. Enough evidence that the court said, if this were all true, you could get a judgment on this. You don't weigh the evidence. You don't go, well, Manson said this person's telling the truth and the defense says they're lying. I'll decide which one to believe. The court shouldn't do that at this stage. So looking at it, if Manson has some evidence of each element, he should be good to go. Now, if the defendant presents evidence, that needs to show as a matter of law conclusively that there's some kind of defect in Manson's pleading. Again, it's not a credibility weighing situation. So, of course, both Wood and Gore made motions. Let's go to Wood's motion first. The intentional infliction of emotional distress claim based on the FBI letter. It was used in court, of course, or custody proceeding, and that can be privileged. Now, Manson points out that just because you file it in court, that doesn't mean that the privilege applies, period, for anything you do with it, if you use it for some other purpose. But then Wood counters and says, hey, wait, there's no evidence that it was used anywhere else other than court. So the court says, indeed, the plaintiff does not point to any allegations of other specific instances in which the letter was published by Wood other than the California custody proceeding. Not surprisingly, the court says, based on the foregoing, the court does not find that the plaintiff, Manson, has demonstrated a probability of prevailing on intentional infliction of emotional distress based on the FBI letter. So the FBI letter that's out. As you'll see as we go further, it's gone at this stage of the case. Infliction of emotional distress based on the recruiting or pressuring and all that stuff. So for infliction of emotional distress, as we covered in other videos, the conduct has to be so extreme and outrageous as to be outside the bounds of what would be tolerated by a civilized society. So that's the law's way of saying it needs to be really bad. So the first prong still goes to Wood that this stuff does have to do with speech, and it's going to go that way throughout this ruling. So Wood says, look, I didn't pressure anybody to lie about Manson. I didn't even put people in the documentary who didn't want to be there. He's got no evidence that I coerced somebody to lie. And the court says, hey, look, the messages that are in the evidence involving Wood or Gore, they're not so extreme as to form the basis for an intentional infliction of emotional distress claim that requires a high level of outrageous conduct in particular. And they don't show that people were pressured to lie. So the court says the court does not find that plaintiff has demonstrated a probability of prevailing on his infliction of emotional distress claim based on Wood recruiting, coordinating, or pressuring multiple women to make false allegations or to be part of the film project. So she wins there on the pressuring angle. So defamation, Wood is tied in here by this conspiracy allegation that she and Gore were working together because there's no allegation in the complaint that she personally made these comments about Groupie, and that's what the defamation claim is against Gore for making allegedly false statements about what Groupie is. Now, the court says that the allegations of conspiracy are insufficient, and again, the court hinted at that back during the discovery order. The court says it does not find that plaintiff has demonstrated that Wood has concurred in Gore's alleged defamatory statements about Groupie with knowledge of their unlawful purpose, or that Wood intended to aid in achieving Gore's objective of making such alleged defamatory statements. I guess as to the statements themselves in particular, the judge is correct there. Obviously, I read Manson's complaint to be an allegation of conspiracy by Wood and Gore. I mean, he said that much, and that they were acting in a common scheme and a common plan to damage him and to achieve certain objectives together, and that if there were false statements made about the Groupie video, that would just be one of the things they were doing. I'm kind of surprised really that the court leaned this far into saying there's no evidence of conspiracy here, or no actionable allegation of conspiracy, right? Nevertheless, that's what the court does. Based on the foregoing, the court does not find that plaintiff has demonstrated a probability of prevailing on his claims based on alleged defamation against Wood. So in other words, it doesn't really matter. You can't show that Wood made the statements or was meeting the legal elements for conspiracy, the judge says. So she's out on defamation. Now, in terms of striking the allegations generally, Manson, of course, is against that totally, but Wood says the plaintiff cannot backdoor his stricken claims back into the case by recasting the FBI letter, recruitment, and groupie allegations as context for his swatting, hacking, and impersonation claims. Those will remain after this ruling. That would subvert the purpose of the anti-SLAPP statute. That's Wood's argument. That's not the court saying it. And Wood notes that refusing to strike any part of a cause of action that rests in part on protected activity defeats the legislative goal of protecting defendants from meritless claims based on such conduct. So the court, however, goes along with that basically and strikes almost everything that Wood asked to be struck. And there's a few paragraphs left in, but for example, the FBI letter, it's gone. So almost complete success by Wood on this motion. Now to Gore. For the intentional infliction of emotional distress on pressuring, the court does not find that the plaintiff demonstrated outrageous conduct by Gore for purposes of this claim of recruiting and coordinating and pressuring to make false allegations. Obviously, that she was going to rule that way because she'd already said that she didn't think the messages that were shown in evidence were extreme and outrageous. And I tend to agree with that assessment. You may have a different opinion. The court does not find then that the plaintiff has demonstrated a probability of prevailing on such claim. How about the defamation and infliction of emotional distress based on the allegedly false groupie statements? Court does not find that plaintiff has demonstrated that Gore entertained serious doubts as to the truth of her statements about the groupie film, because to have actual malice, if you just hear those words, you think, well, as long as she's mad at him, that's malice. But what it really means is she has to have some subjective belief or doubts that what she's saying is true, that she's reckless in this, and it's subjective, not objective. So if the evidence shows that it looks like she probably believed what she was saying, she's in a good position because he's a public figure. As set forth above, Gore testified that she believed the actress in the movie was a minor. I'm not going to get into the particulars of that. Everybody knows what she said, allegedly, and allegedly what Manson says. Nevertheless, the court says based on the foregoing, the court finds that the plaintiff has not demonstrated a probability of prevailing on his cause of action for defamation per se against Gore, basically saying you didn't give me evidence that Gore didn't believe what she was saying. Maybe so, right? I mean, where's the evidence that Gore didn't believe it? Whether it's true or not, that is separate. But in the public figure context, what's the evidence that she either thought, well, I don't care if it's true, or I don't even think it's true, I'm just going to say it anyway. Now, that claim about groupie is also in the intentional infliction of emotional distress claim, so the court has to deal with that. Gore argues the evidence that her statements were made with a good faith belief in their accuracy. In other words, whether she was right or wrong, and whether she should have investigated more or not, whatever, from the things that she'd heard, she had a good faith belief that what she was saying was true. That's what she's saying. And she says that undermines any suggestion that her conduct was outrageous or intentionally made to inflict harm. Okay, I hear that. I understand it. I think Manson's complaint does set out a pretty good case that she was out to harm him. But she's saying in this specific instance, I wasn't saying the things about groupie to intentionally say something false to harm this guy, that I believed it to be true. And that, as I said before, is a very solid argument. The court agrees the deposition testimony cited by Gore undermines plaintiff's assertion that Gore had a reckless disregard of the probability of causing emotional distress through these false statements. So based on the foregoing, the court finds that the plaintiff has not demonstrated a probability of prevailing on his claim that Gore's outrageous conduct included making knowingly false and defamatory statements against Warner, including that there was a minor in the video. So in other words, whether there was or there wasn't, the point was, did Gore think there really was a minor in that video, or probably thought it, or did she think not really, but I'm going to say it anyway? And the court needed to see some evidence of that latter situation, that she was acting super recklessly, or she just knew it was fake and said it anyway. And I didn't see that either in what I saw. So that's basically a home run for the defendants so far. And to to put the cherry on top, attorney's fees awarded against Manson per the statute. So they'll have to submit how much they spent on this, and the court will tax that against Manson. So where does that leave the case? It leaves the case with as we mentioned earlier in this video, and the court mentioned, and so did the defendants, the claims about the impersonating, the hacking, and those things. Those causes of action were not subject to this motion to strike, so they still exist. But Manson having lost pretty much the bulk of the case here is a big issue. So the defendants aren't going to appeal this order because it's a great victory for them. So now it'll be on Manson. If he were to not appeal it, the case could go forward on just the remaining claims, but that is very limited, right? That's not what he brought this lawsuit for, was just the alleged swatting and also the hacking. It's all this other stuff. Someone would think he would appeal for the two reasons. One, that he wants to have his entire case heard, right? And he's, assuming he thinks the judge is wrong, which obviously he does because that's what his lawyers contended. And he's not going to want to pay the attorney's fees on this thing, right? I mean, that would suck too, right? So I tend to think he's going to appeal. And then when he does that, this case will go up to the Court of Appeals, and that takes a long time, whatever, a year or something, unless they find some way to short circuit that. And I don't know what it is. So appeals have not much information flow out of them, as you can see from the Walters appeal. And they take a long time, as you can see from the Walters appeal. So after all the smoke clears tomorrow and the media tells you things that aren't really actually in this order, you will be able to see the real order online. And it's always best to read that yourself. And these are my notes from it, so you can see what was happening here. Short version, the defendants got what they wanted. I think everybody saw that coming, them and Manson included, and it's not really surprised. And now if Manson wants to try and rectify this, if he feels legitimately this is wrong, he has to do it at the Court of Appeals. I wouldn't probably rule some of the way that the judge ruled, but certainly some of it is supported. And also she's the expert and not me. So we'll just have to see what happens. That's it. Thanks. Bye.